That's my Bahama land, yeah. Friends in every place, a smile on every face. Children at play, time with family today. Someone fill my plate, homemade bread, I can't wait. I can't get enough, I will always stay in touch with my Bahama land, yeah.
Rare Voice introduces Bahamaland, an unlimited nationwide calling plan for only $5 a month. So call home today and connect again with Bahamaland. Home never felt so close.
My Bahama land, yeah.
Free National Movement leader Dr. Hubert Minnis defending the former Prime Minister's efforts to negotiate with Cable and Wireless. The Court of Appeal president responds to criticism of the judiciary. Working to reduce traffic fatalities in the Bahamas, and hundreds of students awarded for their national examination results. We have those stories and more coming up tonight. Good evening, Bahamas. I'm Christina McNeil, and your MB12 starts right now. Thanks for joining us. Days after the opposition dismissed the government's renegotiated deal with BTC, a leaked letter addressed to former Prime Minister Hubert Ingraham, which we've obtained, revealed he had tried to keep majority control of the Bahamas telecommunications company, despite his strong public stance to the contrary. In the wake of some critique sparked by that letter, current Free National Movement leader Dr. Hubert Minnis is defending Ingraham's late negotiations with CWC. Dana Smith reports.
Minnis said Ingraham's final attempt to hold on to a majority stake in BTC just weeks before the final deal was signed only shows the former Prime Minister was doing his best to get the best possible deal for the Bahamas.
In a March 2011 letter to Ingraham from then Cable and Wireless Communications CEO Tony Rice, Rice said he reconsidered, at Ingraham's request, the question of majority ownership. The Nassau Guardian obtained a copy of that letter in which Rice advised Ingraham it would not be in the best interest of Cable and Wireless to agree to a minority stake. And the following month, in April, Cable and Wireless paid $210 million for the 51% stake in BTC. Minnis today spoke to our news team in the wake of the leaked letter.
The FNM has always been a party trying to do the best and offer the best possible deal for the Bahamian people. Ingraham would have done the best and his best to ensure that the Bahamian populace obtain the best possible outcome.
However, the current government's lead negotiator for the recently settled BTC deal said the letter only shows that Ingraham knew how unpopular the deal was. Franklin Wilson said Minnis is only attempting to rationalize wrong with his stance on the matter. When asked about Wilson's comments today, Minnis refused to respond.
I'm not responding to Franklin Wilson. I stick to facts. I don't respond to Franklin Wilson.
Minnis also said the current Christie administration would have access to files showing Ingraham's attempt and should not have led Bahamians down a, quote, dead-end path with their election campaign promise to regain majority in BTC.
The Christie-led government has access to all files. They could review the files. They could have made determination that the trail they were on, the road they were on, was dead end, had a dead end. They knew. He should have known if he reviewed the file that he could not retrieve any 2%.
Minnis has said the country is getting nothing new out of the arrangement and criticized the deal as a shameful and cynical betrayal of the PLP's campaign promise to regain majority. Minnis said today if the PLP, quote, did their homework, they would realize the FNM achieved the best possible deal. Instead of focusing on BTC, Minnis said the Christie administration should have moved on to focus on other issues affecting the nation. And as for if he was aware of Ingraham's final effort, Minnis would not divulge.
I don't discuss cabinet matters.
Prime Minister Perry Christie announced earlier this month Cable and Wireless Communications will transfer just under 2% of its shares to the government to be held in a trust fund for the Bahamian people. Reporting for NB12, I'm Dana Smith.
While Court of Appeal President Anita Allen touching on several controversial issues during a special sitting to mark the opening of the legal year. Addressing many members of the judiciary this morning, Allen spoke to minimum mandatory sentences, the death penalty, and recent criticisms of the judiciary. Nikia DeVoe reports.
During her remarks this morning, the Court of Appeal President suggested that the discretion to impose the minimum mandatory sentence be restored to magistrates, pointing out that over 50% of the matters disposed of in that court were magisterial criminal appeals.
And well over 90% of these were appeals against the imposition of the mandatory minimum sentences for drug, firearm, and ammunition possession. As I have noted in my annual report, the sheer number of these appeals places immense pressure on this court. Moreover, it is, in my view, an injudicious use of judicial time to have 3 senior justices doing what magistrates could have done if they had the discretion to impose the appropriate sentence in the first place.
In October 2011, the Ingraham administration reintroduced mandatory minimum sentences as part of its anti-crime legislation. Under that new legislation, people convicted of drug possession with intent to supply or illegal firearm possession faced a fixed sentencing range of 4 to 7 years. However, Allen said justice would be better served if magistrates are once again allowed to use their discretion, suggesting that it is a waste of time.
Suffice it to say that the option of appealing an unduly lenient sentence is always available to the Crown, and restoring the discretion would not affect that option, but would ease the pressure of listing and hearing all of these appeals.
The Court of Appeal President cautiously addressed concerns over the death penalty, noting that the Privy Council's test of what is considered the worst of the worst and the rarest of the rare even confuses judges. But when asked for more information on the topic today, Allen declined to give further comment.
We have considered these decisions, listened to and appreciate the concerns of the public, and what the Constitutional Commission has recommended. I suggest that the time has come to bring clarity to the dispensation of justice in these cases.
Allen also commented on the recent criticisms leveled at the judiciary, saying that judges need to do more to ensure they're accountable.
I do not recall at any other time in my nearly 18 years on the bench such pervasive criticism as is now being made of the judiciary. And I am deeply concerned, as should all supporters of the rule of law.
Allen said she believes judges have not done enough to demonstrate their accountability to the people, suggesting that a seeming lack of accountability may be why the judiciary is blamed for the crime situation, especially due to judges' supposed liberal granting of bail. The public at large has been concerned about the number of people charged with serious crimes who are out on bail. Earlier this month, Prime Minister Perry Christie revealed that 462 men are on bail for serious crimes. At the time, Christie reiterated that more restrictions have to be put in place to prevent those charged with serious crimes from getting bail. Today, Allen stressed that people accused of such crimes are entitled to bail under certain circumstances.
Undoubtedly, the public would have been inclined to inquire, before apportioning blame, how many of the persons granted bail have been awaiting trial beyond the constitutionally mandated period and are therefore constitutionally entitled to bail, or how many have been granted bail because the evidence against them is tenuous or weak, such that to keep them detained would be a breach of their right to the presumption of innocence, or, for that matter, whether any of those admitted to bail have been so admitted for some other good and sufficient reason.
Allen said she's hopeful that judges will strengthen the public's confidence in the judiciary. Reporting for NB12, I'm Nikia DeVoe.
And this morning's Court of Appeals sitting is being called a historic one, as it was the first time in the country's history that a Prime Minister and Deputy Prime Minister attended the event. The occasion was also streamed live on the internet from the court's website, a first for the judiciary. Perry Christie and Philip Davis joined scores of attorneys, judges, and other distinguished guests for the annual report on the work of the court in 2013. Attorney General Allison Maynard Gibson said the performance of the court was nothing short of impressive.
Statistics demonstrate that, and I quote, what the court achieved in 2013 represents historically the greatest performance in the disposition of appeals and related applications by the court, I end quote. The result of this court's guarantee of openness, accessibility, transparency, the use of technology to modernize systems, and its commitment to the rule of law has resulted in previously unknown efficiency in the delivery of justice.
Maynard Gibson noted that every effort will be made in 2014 to make much-needed changes to the physical infrastructure of the court and to complete the implementation of e-filing. Meantime, President of the Bar Association, Ellsworth Johnson, used the occasion to publicly state the bar's concern about the reported removal of stenographers from the magistrates' courts. Johnson says that the move would be a mistake.
I am very much aware that there may be financial and human resource constraints, but we are in the 21st century and we boast of a country as such. A lack of prioritizing the needs of the people leaves us wanting when it comes to access to and the delivery of justice.
Johnson stated that there is a long overdue and pressing need to amend the Legal Profession Act. After the conclusion of the Court of Appeal's first sitting for the year, attendees headed to Jacaranda House on Parliament Street for refreshments. Bahamas Union of Teachers President Belinda Wilson has confirmed that a trade dispute has been filed over what she calls the illegal fingerprinting of expatriate teachers. This comes after expatriate teachers at C.H. Reeves yesterday spoke out against the $100 fingerprinting fee charged by the Central Detective Unit and conflicting reports from the Department of Education and the BUT over the legality of the fingerprinting exercise. Wilson tells our news team that the union stands behind its position that no teacher should provide any fingerprints for the ministry or the Department of Education. She maintains that the fingerprinting exercise is in direct contravention to the Employment Act, and the union hopes the government will see the error in what is being done. Wilson is also calling on police to return the fingerprints that have been taken from expatriate teachers in accordance with the Employment Act. Coming up, promoting safety on the streets.
In this first month alone, 3 people have been killed, is that correct? 3 people, this year in January.
And a little later, hundreds of junior and high school students awarded for national exam results. We'll tell you more when NB12 returns.